It's 2 o'clock time now for Inside the Courtroom, the Senzo Meyiwa murder trial wrap. I'm Linda Mnisi. It's an absolute pleasure to have you with us this beautiful Sunday afternoon. Now, the alleged gunman, Mthobisi Mncube, wrapping up his evidence in chief and largely questioning the state's evidence on the gun evidence. And that's where we are directing our poll question for you this afternoon. So we want to know from you, how do you interpret the evidence regarding the firearm? So those options are on your screen. The first one, 2 guns were present. The second one, it supports 9mm pistol. The third one being evidence is unclear. And the last one saying not enough evidence. So those are the options on your screen regarding our poll question. So make sure that you, of course, scan the QR code on your screen and then start voting. You can also send us your WhatsApp messages on 072-110-5584. That number again on your screen. Let me repeat it for you. 072-110-5584. So make sure you send us your WhatsApp messages throughout the program, and we'll make sure that we read them here. Good afternoon. We start here now. Mthobisi Mncube returned to the stand this week to continue with his evidence in chief. Now, among some of the evidence he dealt with was the description of the clothes the witnesses said he was wearing on the day that Meyiwa was killed. Now, he disputed Sizwe Zungu's evidence, who placed them at the Phosphorus Basotho hostel hours before Meyiwa was killed. Now, the hostel is where the state believes the murder of the footballer was planned. Take a look.
What is it that you wanted to say about this photo?
What I wanted to say is that, as you can see this picture, I am wearing, on the picture, I'm wearing a khaki jacket, a khaki trouser, and black pair of khakis. There is no T-shirt that was had to be said by Zungu, the lime T-shirt. There's nothing like that there. He was just lying before the court so that his story can be heard clearly.
So you totally dispute his version that when he saw you, you wearing a lime T-shirt.
On this picture, if you look at this picture very well, you can see that the dreadlocks are long. They are on my chest. As you see them on the chest, they are actually from the back. They are long, even looking at them on the front. That is a clear indication that if they are pegged to the back, they are much longer. And the dreads are plaited, indicating that if they are not plaited, they become more longer. So the things that were said by those who were in the house and what we see here is 2 different things. Gininda just chose to come and arrest me. And even some of the photos he came with in prison when he came to arrest me. It was 30 June 2020 when he came to charge me for this particular case.
Yes. So he already had pictures of you which are forming part of this photo album.
Yes, there were 3 pictures that he was paging through and he showed to me before he could show me the Senzo Meyiwa's picture. He was asking who is that person, referring to and then he also asked if I was the one depicted there. At that moment he was seeing me, but he still asked if I was the one. And then he asked the other person who's behind, and I told him that was Mapisa. The other person who does not appear clearly, he did not even ask anything about that person, because he also said that it is not clear, it does not show who the person is. This is the first photo that he showed me.
All right, the state also maintaining that Mncube was the gun-wielding intruder who entered the Khumalo home on the night of the shooting. The state is relying on the ballistics test, which linked the gun found in Mncube's possession with projectiles found at the scene. But Mncube says if this gun indeed or was indeed linked to the Meyiwa case, he would have been arrested in 2015.
The firearm that you are referring to, I'm already been sentenced for possession of firearm and ammunition.
Now, we're talking about two firearms here. Yeah. The one referred to by Sergeant Masondo and Dlamini, and the one referred to by Brigadier Ginida is the one that was used as the commandos. Now, when you refer to firearms, you need to be very specific which one, at what point you're talking about.
Let me talk about the firearm they allegedly say they arrested me for. They allege that they found this particular firearm at my place on top of the wardrobe.
Warrant Officer Masondo and Sergeant Dlamini said the firearm that they found on top of the wardrobe in the room where you were staying was a 9mm pistol.
Yes, the firearm that they alleged that they found in my room or in my house, they said it was a pistol. When they arrested me, Dlamini and them, on the 9th of February in 2015, they took the firearm to the ballistics so that it can be checked off whether it has committed any crimes. On the 23rd of February, Dlamini and them now submitted a report. It has 10 cases, including the Senzo Meyiwa case. This Senzo Meyiwa case happened in 2014. Musia said before the court that the evidence that he collected from the scene was submitted on the 30th or the 31st of October 2014, which means that when I was arrested on the 9th of February 2015, the evidence collected at the Kumalos was already at the ballistics. I was arrested after 3 months, 2 weeks after the death of Senzo.
Ngoba buse ballistic nje ufakazi base sigamekweni sika Senzo Meyiwa. UDlamini mayifaka uyilokhuzana isicelo ukuthi bamcheckele. Obviously ba checka ngento ekhona.
Serero, when he or she came before the court to testify about the IBIS, mentioned that the equipment there, it takes the rifle, pistol, and revolver. Cyril continued by saying that machine do the analysis itself or searches itself, but each time when it collects something, it kicks it out, so it kicks it. The expert that is there at the ballistic, I'm not sure exactly what he does or she does, but record what the machine found. Dlamini and them, my lord, never came to me or did not come to me and say to me that they are charging me for the Senzo Meyiwa case.
All right, as always, let's bring in my guest to unpack all of the evidence that we heard in court this past week. I'm joined by commentators in studio, Itu Mukwena, who believes that the state has the right people, while Bongani Masuku also believes the contrary, that the guys in court are not the one. On the line, we have Kabelo Siabi, who's joining us to help us understand the legalities of all the evidence that we're hearing. But let's start in studio. Lady and gent, thank you very much for joining us this afternoon. Let me start with you. The issue around the description has been discussed at length, right, by Mncube. But there's an interesting element here about how he's debating the lime green T-shirt, but ultimately says, I was wearing khaki clothing. Now, in my mind, I'm like, ultimately, the people who were in the house said you were wearing khaki clothing. Surely you would then agree with the fact that it then matches what the people inside the house said.
Yes, I'm back. I'm back. Yes, Linda, I don't see how he has rebutted that evidence, because for me, I feel like he is agreeing with the people that that were in the house. And with main descriptions, like when I say main, the mere fact that he had dreadlocks, right? Whether the length could have been missed because there was a lot going on and there was not enough time to say, hey, it was this long, it was this short. The colors that he was wearing, he's saying, well, I don't know what cappuccino is, I don't know what caramel is. Well, they all come from the same group. Khaki, cappuccino, caramel, it's all the same thing. I might not see it the same way you see it, but at the end of the day, it's the same thing. Big eyes. He says that I don't have big eyes. Well, I know Judge Rata is looking at him and saying, so you have big eyes, okay? And then he says that I don't have contours. There was a fight that ensued in court if you look at that man's face as he's approaching the correctional services men, you can see those lines. He's not in the same state now. He's relaxed, he's chilled. When he went into Kelly Khumalo's house, he did not have that face on. So definitely, he has not rebutted that evidence. I can't even wait for him to rebut it anymore because we're in cross-examination. It's a bit too late.
And the issue of the firearm, I mean, he says if this firearm was linked to the Meyiwa case, he would have been arrested back in 2015.
No, well, it depends. It depends because Brigadier Geninda did not have that information when he started. Remember, Brigadier Geninda only got that information through Ntanzi's confession. Nobody knew that this gun belonged to accused number 3 because that report was not in any police system. Even when they got the projectile from the Senzo Meyiwa case, they could not match it with anything else when he had committed the crime that he committed in 2015 because that file was never ever filed anyway. And he says that the Masondo and Lamini, the people that actually found this gun, are good policemen, and I beg to differ. I'm saying no, they were probably helping you. You probably had policemen that you were working with who were trying to protect you. That's why you flew under the radar and nobody knew anything about you. There is nothing about you in this case because policemen were probably assisting you.
Yeah, let me come to Bongani. He's paging through his case law that he usually brings us in studio today. I mean, you've heard the questions that I've asked you to, and I want your take on both of them because, number one, the issue of the description, and then surely you will want to take the direction of the holistic approach. The complexion, he says, well, they described a darker-skinned person, and I'm not dark-skinned. But essentially, there's also that element of the lime green T-shirt, which he says, well, he wasn't wearing that. He, in fact, was wearing khaki clothing.
S versus Blom. I'm going back to that one.
Yeah.
Case law, right? It's their responsibility to prove their case beyond reasonable doubt, right? Mm-hmm. Not our responsibility. They have the burden. All that we need to do is to poke enough doubt. Here's a question.
Reasonable.
Here's a question. If you look at the evidence, right, can you convict him on the basis of the eyes and just the skin tone? Can you convict him on that basis alone? You can't, because he or they must argue the evidence. In totality, it must prove that this guy was there. So failure to which, I'm afraid. And I want to go back to this. Just on the, I don't want to struggle. We are not here to sweat. I quoted a case law this other time. I said Timothy Omotoso, and I subsequently found other case law that just based this judgment on. You will remember, I want to hammer on this principle. The judge says, Timothy Omotoso, I'm not convinced that you are innocent. But because the state did not prove its case beyond reasonable doubt, I'm going to acquit you. What I'm trying to say is, as long as they have not proven all the facts, goodbye. That's what I'm saying. Goodbye.
Okay. Let me bring in our legal analyst, Kabelo Siabi. Kabelo, I mean, you've been hearing what, our commentators, people that follow the case and represent the voices of the masses who are very much interested in this matter, I've had to say, about the issue of the description, but also the issue of the firearm. And I know that issues of firearms is something that is challenged at length, particularly in criminal matters.
Thank you, Linda. Linda, one must remember that there is a distinction between real evidence and other evidence that is led in a trial. Now, the firearm is real evidence. And with a firearm, one must look at the sequence of the events in this case. The accused is found with a firearm in his room. The firearm is sent to the ballistics. It is tested as to whether is it a functioning firearm as per the description in the law. Now, test shots are fired. Those are then compared with the firearm and a report is given. But what is very interesting, and I think what most people forget, is that the test test cartridges and the test bullets were then filed by the first analysts. They were not acquired, or they were not put on the classification system of the firearms by the laboratory. Now, it is only at a later stage when a second comparison is made with the firearm and the previous results, and that is where the link is. Now, that is a matter that the court is going to look at, because that's real evidence. And from the evidence of the state, it is established that this firearm is a firearm that was used at the murder of Senzo Meyiwa. So the issues that have been raised in the evidence of the accused, unfortunately, most of them is just commentary, and not, he is not coming up with any facts that rebut or that shows that the evidence of the state is inaccurate or it is untrustworthy. The evidence has more been a critical analysis of, he said this is not possible, this is not what happened, but it's more of an argument than a setting out of facts. The court looks at the facts from the state case and the facts from the defense case. And these are looked at holistically, not in silos. They will all be looked at holistically. Now, when it comes to description, you must remember that when people come unexpectedly and an event happens, there is not time to record each and every minute detail of what happened at the scene. So it is actually expected that there would be certain points that were not properly observed, certain indicators which were not properly observed, and the court will be mindful of those facts, that in a moving scene, there might be discrepancies as to observation because the people were not ready and waiting to observe and record each and every event.
All right, I want us to take a quick ad break, because when we come back, we get more into this evidence around the firearm, because one of the things that Mthobisi Mncube speaks about is the issue around the sealed bag, which was broken, and he says that possibly, or the gun shouldn't have even been assessed, because they too say that they shouldn't have accepted it. So according to the law, they shouldn't have even assessed that particular firearm. So more of that after this. Welcome back, and thank you for choosing to stay with us. If you've just joined us, you're watching Inside the Courtroom, the Senzo Meyiwa murder trial wrap, and I'm Mnisi. Now, we continue here. Mncube also testified about the open seal bag that the firearm was found in. Now, you'd recall that the court was previously told, or previously heard, that the firearm was found in an open seal bag because it was destined for destruction. This has been one of the most contentious issues that speaks to the chain of evidence. Take a look.
Yesterday, you were still explaining about the fact that Mr. Mangena came and told this court that he received a firearm in a broken seal bag and everything. That's where I then interjected and then introduced this, which is contained on record here. You can proceed from.
As Mangena also has explained that he does not receive the exhibit or the firearm when the seal bag is open, and also Mjali, who is the one that was giving him the firearm, also mentioned that he was not going to accept or receive if the seal bag is open. That clearly shows that that is the way they work, that they don't receive any exhibit when it is open, since you don't know exactly what happened to that exhibit. Maybe the evidence has been tampered with, has been changed, or maybe they've put something else which you are not aware of, according to the police.
All right, let's continue the conversation still with my guests in studio, Itumukwena and Bongani Masuku, who are commentators following this case religiously, standing on opposite fences. It is tense in studio. Bongani has been passing pages. So I'll start with you, Bongani. The issue around this open seal bag, and I want us to, before we get into your research, right, I want us to speak to the facts, the evidence before court, because the court will deal with what is before it, right? The evidence of Rulofse and where the evidence or the firearm comes from, and the critical question that I think the judge keeps asking, is this not the same firearm that Rulofse tested? Let's look at that in light of that bite that we've just played around the broken seal bag and the contamination, possible contamination of that particular piece of evidence.
Very interesting. I've been waiting for that one. Number one, just to remind people, this firearm, Mncube is arrested in 2015. Right. This firearm, around February, it was collected by Lokusbong Sen Dlamini, because Masondo had booked it in for ballistic test prior to that date. Now, 2015, it is entered into IBM system. Nothing detected. Up until 2020, 5 years down the line, boom, it appears. But now, it takes me back to the word of a police officer. And those words have never been contested. Nowhere. General Mkhwanazi says, the modus operandi says, you don't steal on the crime scene, but on the way to the lab, you swap things. We have already seen what transpired at Madlanga Commission. So we know that police are capable. Because we read message, we were made to hear some messages that actually the drugs that were discovered at Arlington, the number that we've been discussing, actually is different than the number that it is said to have been a discussion between General Khan and the head of IDEC, former head of IDEC. So that then established this principle that we know that, so things happen on the crime scene. When it comes to the Senzo Meyiwa trial, again, under oath in Parliament, it has never been disputed. General Musikil said that crime scene was contaminated. So why will you then trust the firearm that is received? And I want to repeat this. Why will you trust a firearm that is received in an unsealed bag when from the crime scene it was already contaminated? In fact, let me make it worse.
Do we have that evidence, Bongani, that it was contaminated from the scene? And if so, who brought that evidence?
I'm going there, Linda.
Yeah, give us the
Do you remember that, I think it is in Tapseng, who said she was in the back of the van going back to the Meyiwa house, right? I mean, sorry, the Kumalo house. Do you remember that she said that and the police says,
she said what?
She said that she was in the back of the van and she saw some certain things there, and police says, no, we actually
back
did
of
not.
Which van?
The police van that from Buthelong Hospital, that traveled from Buthelong Hospital back to the Meyiwa house after they discovered that it was actually a crime scene. Remember that the police arrived at the crime scene. They did not call on the crime scene. They went to Butselong Hospital. At Butselong Hospital, they then realized, actually, that's a crime scene. And then they went back, and Tapseng said, I was in the back of that van, and the police says, no, you were not. But there's something that Tapseng said. She said that when she got there, I think it's Makumalo who was busy telling them that this hat, she even picked the hat. This hat belongs to...
But we're talking, Bongani, I'm going to have to interject, sorry, in the interest of time. We're talking about the firearm and not necessarily the issue of the hat. We're going to come to the hat.
I'm not discussing the hat. I'm discussing the crime scene.
Yeah, the firearm, not the crime scene, the firearm. And you're saying there's a potential mixing of the evidence. And I'm asking you, is there evidence that points to the fact that evidence of the firearm was contaminated or the firearm may have been changed, given the fact that rule officer came to testify and said, this is the same firearm that I tested in the Cleveland case?
Mnisi, give Bongs a chance. Bongs is going to cook this one next to me. She's going to have amnesia.
Yeah, I want us for the benefits of the viewer,
yes,
for the benefits of the viewer to understand what the evidence in court is.
I understand that, but the evidence in court also challenges, this is the defense, they are challenging the chain of custody. Hence, they've been pointing out, and hence I'm also pointing out the fact that on the crime scene, the crime scene was never managed the way it should. So a lot could have happened on the crime scene because it was not including the firearm.
Could have. Okay, I get you. Itu, let's come on this particular aspect and on the same facts around the evidence that we've heard around the chain of evidence and ultimately the people that came to testify about how the firearm moved and ultimately where it was kept, but also again the evidence of rule officer. Is this the same firearm that was tested in Cleveland that, of course, the state now says is the same firearm that killed Meyiwa?
You know, I like in the words of Judge Rata, which case are you watching? So we have, firstly, we have Mr. Mnisi and accused number 3 saying the gun that was found by Dlamini and Masondo is my gun. I was sentenced for this gun, therefore you cannot sentence me again for the same gun. We have rule officer who says that this gun that accused number 3 saying is my gun is the same gun that Mangena says he tested. And then Mnisi stands up and says, it's not disputed that this is the same gun. It's not disputed that Mangena matched this gun, right? So we're clear on that. That gun that was found by Masondo, that was tested by rule officer, it's the same gun that was tested by Mangena, which Mangena test positive for the projectile that was found in the Senzo Meyiwa case, right? Rule officer was asked, how can you confirm this is your gun? He says, my lord, I engraved this gun. It had no serial, I found the serial number. It's the same gun. This gun was in court. It was presented to rule officer. He says it is the same gun. Let's go to the issue of the open seal bag. This gun was destined to be destroyed. So what chain of custody are you talking about? Because it's going to be destroyed. We have reached the end of this gun. But anyway, Mangena takes the same gun, right? He tests it. He matches it to rule officer. If anything had changed on this gun, how could he have matched it? How could he have matched it to rule officer's gun? And then go further and match it to the Senzo gun? Anjan.
One might argue, Itu, that there is the idea of the revolver in there, which then suggests that could it have also been a revolver?
Well, that's you arguing it could have been. That's not the evidence. Let's talk to the evidence. What gun killed Senzo Meyiwa? It was a 9mm pistol, not a revolver. The revolver is between you and my friend over here and the people in the house that saw the revolver, but they did not see the revolver shoot Senzo. There is no evidence in front of Rata that he needs to consider that a revolver killed Senzo. There is no evidence.
Yeah, let's bring in our legal analyst. I mean, Kabelo, the one thing that we seem to be debating here is the issue of chain of custody, and also given the evidence that has been given and tendered in court, And I specifically mentioned rule officer because that's the one question that the judge keeps asking. Is this the firearm that was tested by a rule officer? Is that in dispute? Has the barrel been changed? And I remember at some point, Advocate Ngumalo, tried to say somebody could have, and I stand corrected on how I quote him there. But Kabelo, the importance of chain of evidence, and with your knowledge, whether or not that has been challenged.
The chain of evidence, Linda, would have been very important from the time that the gun was found in the accused's place and taken to the laboratory, because that would be the time when a switch could be made of the firearm or parts of the firearm, and therefore the results at the laboratory would be inconclusive that this firearm is the same firearm found in the accused's place. That chain of evidence was the most important part, because at that stage, that's when the physical attributes of the firearm could have been altered. But having that piece of the chain of evidence intact, that this firearm was discovered in the room, it was taken, booked in, taken to the laboratory, it was tested by rule officer. That piece of chain is intact. Now, what also is to the advantage of the state is the fact that there is confirmation from rule officer that this is the gun that was tested by Mangena. The tests of Mangena match those of rule officer and also match the projectile that was found at the scene. Therefore, it completes that cycle, which on the issues that are material, there is evidence before the court that this is the same firearm which was used in the murder of Senzo Meyiwa.
Yeah, and just before we quickly take a break, I mean, I was asking Itu the same question around the idea that there could have possibly been another firearm, because when I listen to Advocate Mnisi, he says the firearm that Mangena tested or assessed, we're talking about two firearms here. There's your firearm and the firearm that Mangena tested. And given what we've heard from, ballistics expert, Chris Mangena says, if it doesn't mean that the revolver fired the fatal shot. People may have well observed it, but there is no evidence that points to the fact that, that particular revolver fired a shot. There was even a debate in court this past week about whether or not it releases cartridges and all of that. Just talk to us about the idea of creating doubts in the sense that there could have possibly been another firearm, and how that, under what circumstances would that argument stand?
The argument would have been, there was evidence that would say the projectile which was recovered at the scene of the murder of Senzo Meyiwa, that there were no sufficient marks or striations on that cartridge that matched the firearm. If that was there, that would have created doubt. But if one takes the totality of the evidence, you must remember that even the ballistic expert that was retained on behalf of the defense, he simply said because he could not find enough marks, he could not exclude or include that firearm. So basically his finding was neutral, faced with Mangena's analysis, which is supported by those who verified his results. Therefore, on the scale, there is no sufficient doubt created as to the issue of the firearm not being the firearm that was used at the scene in Phosphorus.
All right, we've run over a bit there with our break. Let's take a quick ad break. More of the evidence when we come back. Okay, Sibongiseni, good afternoon. I hear you've just joined.
Yes. Afternoon, how's it?
Good, good. You couldn't resist the heat. You could not resist the heat. Yes, she says studio.
No, there is something that is misplaced about Kwanazi and what. We don't have that evidence.
Okay, hold on. We'll bring you in. Welcome back and thank you for choosing to stay with us. A quick reminder of our poll question. We want to know how you interpret the evidence on the firearm. The options are on your screen right now. Evidence supports 2 firearms. It supports a 9mm pistol. Evidence is unclear. Not enough data. So 64% leading with 2 guns were present. So indeed, those are the results at the moment. But of course, you can scan the QR code and continue to vote. We also asked you to send us your WhatsApp messages, and let's read those. One coming in from Anonymous, who says, Linda, Bongani's arguments are devoid of the facts of the case. Facts of the case. The totality of the evidence is going to weigh against the accused. As one of the legal counsel said, reasonable doubt is not absolute doubt. So that's a message that's coming from Anonymous on our WhatsApp line. Let's take a look at Jabulani Ngesi, who's all the way from Durban, who says, hi, Linda. Let's not conclude that the guy might be the wrong person alleged to have entered and fired shots that killed Senzo Meyiwa at Khumalo's home. The state is yet to cross-examine him to reveal his link to the case. So that's Jabulani Ngesi in Sydenham in Durban. We've got another one from Griffith Zabala, who says, hi, Linda. Reference to the revolver is irrelevant. The ballistic reports confirmed the gun that killed Senzo. The evidence shows that the seal was opened because the gun was due for destruction. The defense is relying on procedures and is failing to present counter evidence. So those are the WhatsApp messages that are coming through. So make sure you send those numbers. Just a quick reminder, I don't know if we have that number that we can play for you right now, 072-110-5584. That is the number that you need to send your messages to, 072-110-5584. So make sure that you send us your WhatsApp messages and we'll, of course, read them on the program. So let's continue with the evidence now. We're also joined by Sibongiseni Gunene, who's also our regular analyst on the program. Sibongiseni, thank you very much. It's been very heated here in studio regarding, of course, the issue of the firearm, which has taken center stage, right? We've seen the poll results. So a lot of people suggest there were 2 firearms at the Khumalo home. Obviously, there's a lot that you've picked up since the conversation started, and I want to know what your angle is.
Hey, good afternoon, Linda, as well as the guest and my learned friend and the viewers at home. Well, in terms of the evidence that we have from the people who were inside the house and the weight with the ballistic expert being Mangana and the others. Well, the people who are inside the house, we need just to be mindful. There is none from the people who are inside the house who has intimated that at the time when this shot was fired to the deceased or whether to the floor, then they described the firearm that fired the shots. Nobody has done so. Well, they have said when the two intruders entered the house, then they saw a firearm with a wheel. But then here we have objective evidence. Objective evidence being the projectile which was recovered from the crime scene. And that can only then has to be determined ballistically. Right. On ballistically, then such objective evidence was tested against the gun which has been alleged to be used in this matter, by the virtue that now we have a perpetrator who was convicted in relation of murder, and then there is a firearm in relation to the said perpetrator. Investigators then, at that time they didn't have any firearm, but then now that we have Mncube, of consequences, then they followed up that this gentleman, does he has a firearm? Was he convicted in relation to a gun? And then they took that firearm, investigating it as to whether could it be the firearm that was used in the case of Senzo Meyiwa. Then how did they do so? Now we have an accused person who then is linked to the crime. They took the objective evidence, which was the projectiles which were recovered from the crime scene. And such a projectile then were tested against the said firearm. Then that is how then now it is defined that the firearm which was used on the day in question could not be a revolver, but a 9mm, which is the one that has tested positive. So there is no way you can contest that evidence by the virtue of that people who were inside the house has observed a firearm with a wheel versus the objective evidence and the ballistically report which is coming from the ballistic expert who tested the gun.
And I want to come back here in studio because Bongani, you're itching to respond. Let me give you an opportunity.
You see, this is what I find it strange, that everybody today has amnesia, including the lawyers on the line. All Africans have amnesia. Do you remember the evidence of Mchali? Do you remember Mchali, who works at local SAP 13? Do you remember what he says? Despite the fact that the gun was destined for destruction, it did not mean that the gun had to be handled recklessly. He said the issue of keeping that intact is applied till the destruction. He's even said there was a time where he was questioned around the fact that what would have happened if you had to deal with that unsealed. He says, nope, I'm not involved. So everybody's forgetting Mchali, who works at 13. Now, we brought the issue of chain of custody because of, they will remember, Botha versus S, state versus Botha, state that the purpose of proving chain of custody is to ensure accused persons are not convicted on basis of unreliable, possibly contaminated or altered evidence, though evidence or admission by the defense. Okay, that's another part. But I'm saying the purpose of chain of custody is to make sure that the accused are not sentenced.
Before I bring you in, let me bring Kabelo Siabi. Kabelo, maybe just to respond to Bongani there around what he's pointing out now.
Yes, Linda, I think Bongani misses the point. The point is, when did the contamination or the possible contamination arise? Now, as I said earlier, from the time that the firearm is recovered from the room, and it is taken to the ballistic for the first test by rule of say, if there was contamination or suggestion of contamination then, it would have carried weight. But once rule of say has tested the firearm and he has acquired the properties of that firearm through the bullet tips that he fired in the test, and he had acquired also the properties of that firearm on the cartridges that he fired during the test. And later, there is irrefutable evidence that says this test by rule of say and the test of Mangena speak to this being the same firearm. The issue of the sealed bag at the later stage is not really going to take the matter anywhere. The contamination would have been material if it had happened from the time of the seizure of the firearm and the first test by rule of say.
Yeah, let me come back to studio and give you an opportunity to also have your say with regards to the issue of contamination, because Bongani seems to suggest that even the possibility of there being contamination really carries weight.
Hey, when you must find a corner, you must try to find a corner. Relax. This is a case that has been investigated that is based on circumstantial evidence. Now, when you tell us about Bloom and how you need to look at evidence in totality, you actually need to look at the evidence in totality. It is the state case that, yes, they came to the scene and they wiped the scene, they cleaned the scene. They're not running away from that. It is Mangena that comes and say, I found the seal open. He didn't have to share that information, but he has given us the information. Now, the judge will have to, just because now the seal was open, it doesn't mean that we cannot use that evidence. There is scientific evidence. He matches the same gun with the one that Rulov says, this is the gun that I found. And it's the same one that Mangena found. And for me, it is Advocate Mnisi saying, that is not in dispute. So what is my friend disputing?
Yeah, Smugsani, before we take a quick break, I mean, there was a point when Mncube changed his plea when it comes to this gun. So it comes as a surprise to me when we're now having conversations about the possibility of 2 firearms. If you remember, at some point, he came back and changed the plea around this firearm, saying that I cannot be convicted twice on the same firearm. What does that mean then if we're going to question the possible contamination of this firearm?
Yes, Linda. In fact, we don't even start there. The simplicity of it, Rata has already intimated that to these guys that there is an evidence of Rulose. In fact, there is scintilla of evidence here. Rulose's evidence, as my learned friend is saying, that there is no one who's disputing the result or the chain of evidence at the time when it was tested by Rulose in Cleveland case, right? And of consequences, then Mnisi, then they pleaded the Atrafos here and says they cannot be, the Atrafos convey, that they cannot be just convicted twice in this same firearm, which then they own it and which then they purchase it from the black market in Wanongo. So the firearm they are talking about and the state which alleges that this is the firearm in which you're in possession of it unlawfully so, is the only one which was tested by Rulose, right? If we are not disputing that and also accede that this is our firearm, then the issue of a chain of custody then does not find any expression by the virtue that now the exhibit bag was open, because Mangena and Rulose were going to have different results insofar as confirming whether this is the firearm which was tested in 2015. In the absence of any contradiction between the two insofar as determining the firearm, then you will be just shooting on the air when you want to go accordingly to the issue of chain of custody. That is the chain of evidence, mean to say.
Yeah.
You're going to suffer there.
Yeah. All right, let's take a quick ad break. When we come back, we look ahead because Mthobisi Mncube is still on the stand and is currently being cross-examined by other defense lawyers. So more on that when we come back. We are on the last segment. We literally have a minute each right? So straight to the point. So
On which one?
So what I want to ask is, because he's concluded his evidence in chief, he says they have not found the hitman because he left his DNA and the DNA does not match him. And the issue around all the other pieces of evidence and Kelly Khumalo, constantly bringing Kelly Khumalo to his evidence to say,
Okay.
All right, welcome back. Let's continue the conversation here in studio. Mthobisi Mncube, still under cross-examination. Bongani, let me come to you a minute to, we're giving you a minute to wrap it up. I mean, holistically, we know Mthobisi Mncube has wrapped up his case, evidence in chief rather, and essentially he says they have not found the alleged hitman because the hat in the house, the DNA that was picked up there, does not match his. Therefore, that alleged hitman has not been found. The issue around Kelly Khumalo, consistently asking, why is Kelly Khumalo not here if she's the one that sent us to kill Senzo Meyiwa?
Okay, you know the cell phone evidence, the DNA test, and then the firearm.
Yeah.
Those 3 points. For me, we know that the cell phone evidence doesn't place him in the crime scene. The DNA test excludes him on the probabilities of doubt. I'm not sure you guys will finish it for me, but one thing I know is that S versus Circle says a court does not need to be convinced that the accused version is true, only that it's reasonably or possibly true. That's all I'm saying. We'll come back to the issue of Kelly Khumalo the other time. Uguti, the state deliberately chose not to bring her so she could testify as to what type of a gun that killed her, including Khumalo, because according to the testimonies that we've heard, those are the 2 people who saw Senzo Meyiwa dying or being shot at. But the state, for some strange reasons, deliberately chose not to go that route. I'm not sure why, but it's fine.
You know exactly why they chose that, because it's evidence before court, Bongani. We can't pretend like it's not there.
If you're trying to find a corner, you'll get any corner. We all know why Kelly Khumalo has not been called. And I feel for you, Ncube, and I agree, she should be there next to you. But they decided to take a different strategy. Now, Ncube has completed his evidence in chief and he's been cross-examined. And I fear for him because Dr. Zibanda is going to pull up with the facts. And he is not going to have answers because he was not led with the correct information. Half of the propositions that were made by Mr. Mnisi were not accurate or complete evidence. He's going to be confronted with that evidence. I heard him when Mr. Ramasipila tried to speak about the other case, and he said that, I'm not going there. Well, with Mr. Zibanda, you will not be able to do that. And I hope you prepare yourself. And you know what? I am looking forward to him actually answering the serious questions that he needs to answer in order for us to say, actually, you know what? This man has been wronged, which is not it.
Yeah, Kabelo, let me come to you as we wrap it up. I mean, what has been your impression of Ncube's evidence in chief and the points that we've touched on?
Linda, most of the evidence in chief dwelt on the aspect that I alluded to earlier, where the witness was basically giving his own understanding, summation, and criticism of the evidence of others. And there were very few factual matters that he placed before the court to say, look at these facts, and these facts show that the state case is unreliable. That is what is required. The issue of assessing evidence as to its reliability or whether it is sufficient, that unfortunately is entirely in the hands of the judge, and the witness making those opinions for a very long time, unfortunately, does not assist.
Yeah, let me come. All right, sorry about that. Let me come to you then, Sibongiseni, as we wrap it up. Unfortunately, we're running out of time. You know, your impression of Mthobisi Mncube's evidence in chief.
Well, Linda, I hear that the guest here, who's Bongane says, speaks about a version which is possibly true that has to be given by the witness, is citing a case law, but then, well, it is okay. Unfortunately, then we were waiting for a version that will be possibly and be believed by the court. Unfortunately, it has never happened in this matter. Mncube was busy commenting and criticizing and saying people are lying and all those things. He did not give the version about how then the court has to, in fact, explore the set principle that the gentleman is talking about of a version which is possibly true. Well, then he mentions also Kelly Kumalo that is not before court. Unfortunately, that can't be taken as a version that the court has to take into cognizance when you said, why do you try me and leave my co-perpetrator? So that's not a defense in its nature. Well, he also ventured to the fact that DNA does not link him. It is okay. The state, when they were applying for Section 174, you'll remember, and they also commented on the DNA. They say DNA, they are regarding it as being neutral because it does not prove any point insofar as the evidence is concerned. They didn't even have any intention just to rely on it in proving their matter. So you need also to take that into cognizance because evidence is weighed holistically. He might rely on the DNA, but then there's description, what are you going to do about it? Then there's a firearm, there's confessions, there's Zoom's evidence, there's multiple pieces of evidence that then has to be weighed. So you can't say because DNA didn't say so, then therefore the entire evidence has to be disregarded.
Yeah.
So maybe let's wait because also the other councils are doing something which then is similar to what Mnisi was doing. Maybe he will, but they're supposed to cross-examine him than leading evidence, or he calls witnesses who are going to testify. But at the moment, his evidence is an element of not being giving any persuasive to say this guy is detaching himself from the crime scene or commission of the offense.
All right, thank you very much for those inputs. Bongani Masuku, Itumukwena, commentators joining me in studio, while Kabelo Siabi and Sibongiseni Gunene via our phone line and video link are our legal analysts. Let's check in with your poll results today, looking at what you've had to say. 71% of you saying there were 2 guns present, looking at, of course, the evidence that is before court. And that's how we wrap up the show. Thank you very much for joining us. You and I will see each other again next week as Mncube continues to testify under cross-examination. So until then, take care.